Good afternoon, everyone. I'm Jerry Brown. I'm on the Executive Committee of the American Constitution Society Chicago Lawyers Chapter. Welcome to our event today. Our program has qualified immunity turned into strict qualified immunity, shielding police officers under Section 1983. It's my privilege to introduce our producers, our speakers for today's event. First, the American Constitution Society for Law and Policy is a 501c3 nonprofit, nonpartisan legal organization through a diverse network of our nationwide network of progressive lawyers, law students, judges, scholars, advocates, and many others. Our mission is to support and advocate for laws and legal systems that strengthen our democratic legitimacy, uphold the rule of law, and redress the founding failures of our Constitution and enduring inequities in our laws in pursuit of realized equality. Our moderator for today's event is attorney David R. Melton. David Melton is a semi-retired attorney who graduated from the University of Wisconsin-Madison with an undergraduate degree in history in 1974 and the University of Chicago Law School in 1977. Largely retired from active practice in 2009, he remains active in bar associations and law reform efforts in the areas of campaign finance reform and election law, civil liberties, including police oversight, federal courts, and intellectual property. He worked on a number of pro bono cases in those areas while in practice and continues to be active in those areas as a co-chair of the Chicago Council of Lawyers Civil Liberties Committee. He is also an active member of the Reform for Illinois, the Chicago Justice Project, and the Chicago chapter of the American Constitution Society, as well as a member of the Lynn Inn of Court. Professor Joanna Schwartz is a professor of law at UCLA School of Law. She teaches civil procedure and a variety of courses on police accountability and public interest lawyering. She received UCLA's Distinguished Teaching Award in 2015 and served as Vice Dean for the Faculty Development from 2017 to 2019. Professor Schwartz is one of the country's leading experts on police misconduct litigation and the author of the recently published Shielded: How the Police Became Untouchable. Professor Schwartz is a graduate of Brown University and Yale Law School. After law school, Professor Schwartz clerked for Judge Denise Cote of the Southern District of New York and Judge Harry Pregerson of the Ninth Circuit Court of Appeals. Attorney Juan R. Thomas is of counsel to Quinteros, Prieto, Wood, and Boyer, PA, and is the founder and principal of the Thomas Law Group. Mr. Thomas's practice includes the following specialties: real estate, estate planning, labor employment, and family law. In addition, Mr. Thomas provides counseling and training to firm clients in the area involving personnel, collective bargaining, and business development matters. Mr. Thomas is a past president of the National Bar Association, having served as the association's 75th president during the 2017-2018 year. Mr. Thomas is also a member of the Executive Committee of the Chicago Lawyers Chapter of American Constitution Society. Professor Evan Bernick joined the NIU Law School faculty in 2021. He teaches courses in constitutional law, criminal procedure, administrative law, and legislation. From 2020 to 2021, Professor Bernick was a visiting professor at the Georgetown University Law Center and the executive director of the Georgetown Center for the Constitution. Before that, he served as a clerk to Judge Diane Sykes of the U.S. Court of Appeals for the Seventh Circuit. From April 2017 to April 2019, he was a visiting lecturer at Georgetown and a resident fellow at the Center for the Constitution. His scholarship covers a range of topics from constitutional law to philosophy of law to social movements and law enforcement. Professor Bernick received his bachelor's degree in 2008 from the University of Chicago, where he studied philosophy and graduated with honors. He received his Juris Doctor in 2011 from the University of Chicago Law School. And last but not least, Professor David Shapiro. He's the ex-professor David Shapiro, the executive director of the Chicago Lawyers Committee for Civil Rights under the law. David, he became the executive director in January of 2023, and he leads their work. Prior to joining the Chicago Lawyers Committee, David devoted his career to fighting racial injustice and civil rights, first at the ACLU National Prison Project and most recently at the MacArthur Justice Center attorney and a Northwestern law clinical professor. In 2016, David founded and became the director of the MacArthur Justice Center's Supreme Court and Appellate Program, growing the team from just him to a team of 16 staff members and working to ensure that people subjected to police brutality, indecent prison conditions, wrongful convictions, and other law enforcement abuse have the best representation possible in appellate and Supreme Court cases. In 2022, the MacArthur Justice Center was honored by Bloomberg Law as a pro bono innovator for the work of the program. David graduated summa cum laude from Harvard College in 2001, was a Fulbright Scholar from 2001 to 2002, and graduated from Yale Law School in 2005, and clerked for Judge Edward R. Becker on the Third Circuit. My pleasure to turn matters over to our moderator, David Melton.
Thank you, Jerry. And thank you all for attending today. As you can see, your attendance is very important to us, as you are a select group. I want to thank Jerry first for making this facility available to us and for making lunch available to those of us who have been able to physically attend the program. Before we get started, I just wanted to give you a brief overview of how we will be proceeding today. Each of the members of the physical audience should have received copies of an evaluation form and a list of related background materials. These are on the table outside just as you come in next to the sign-in sheet. You should sign in with your IDC number if you want credit. For people online, we will handle that via email. We can also distribute the background materials and the evaluation form by email probably tomorrow. For people who are here, if you could hand the evaluation materials back into me at the end of the program, I'd appreciate it. For people online, you can send them to me at david.melton.law@gmail.com. I'll repost that address at the end of the presentation. Any requests or questions about CLE credit should also be directed to me. So the first half of today's program will focus on the current state of the law with respect to qualified immunity and how we got here, primarily in the context of civil rights litigation against police officers for constitutional violations. Evan Bernick, an expert on the adoption of the 14th Amendment, will begin by explaining how Congress initially created a remedy for constitutional violations and how the Supreme Court initially constrained that remedy and then added the defense of qualified immunity in the 60s. Joanna Schwartz will then pick up and will explain how the qualified immunity defense has evolved, as well as related doctrines that together severely limit the effectiveness of the statutory remedy. And as Jerry had mentioned, she's also the author of the book Shielded: How the Police Became Untouchable. A little more about that later. Joanna will be followed by David Shapiro, who is an expert in the Kafkaesque world of civil rights litigation involving prisoners. He will describe some of the other practical hurdles that impede the effectiveness of the statutory remedy further. We will then conclude the first portion of the program with a review of some of the myths underlying the qualified immunity defense and calls for reform or its elimination, with Juan Williams describing the ABA's view on that subject. Sorry. Sorry. Juan Thomas. My mistake. Chalk it up to old age. The second half of the program will focus on the possible reforms in a discussion involving all of our panel members. We will look at proposed legal doctrinal reforms, practical reforms to the broader police oversight system, and even broader abolitionist proposals that go beyond reform. So with that overview, Evan, the floor is yours to start the discussion of where we are and how we got here.
Thank you, David. it is harder to explain why we have qualified immunity than it would be to explain why we didn't have it. I could do the latter in a single sentence. Where there's a right, there's a remedy. That's from Marbury v. Madison, of course, the case that everybody remembers for the fact that it established judicial review and basically nothing else about it because why? It is basically otherwise irrelevant to our law. At the time that Marbury was decided and well into the late 19th century, it didn't matter whether a person was a government official. If you violated somebody's rights, you could sue them. There existed a strict rule of personal official liability for violations of common law rights to life, liberty, and property. That might sound harsh. It was. And Justice Marshall, author of Marbury, also author of a critical opinion affirming the Marbury principle, where there's a right, there's a remedy, knew it. In 1804, in the case of Little v. Bareem, the court took up the case of Naval Captain George Little, who mistakenly allowed a Danish boat, or mistakenly captured a Danish boat and was subsequently sued. Federal law allowed the boat to be seized only if it was going to a French port, which it was not. But President Adams had issued broader instructions to seize boats both going to and coming from French ports, and Little was following those instructions. Seems like a reasonable mistake, and from what we can tell, Little had the best of intentions. He was relying upon the president's instructions. Chief Justice Marshall reflected in his opinion for the court, the first bias of my mind was very strong in favor of the opinion that though the instructions of the executive could not give a right, they might yet excuse from damages. But ultimately he concluded that they could not. Where there's a right, there's a remedy. This principle was honored throughout the 19th century. Here's how it operated in practice. A plaintiff would sue a federal officer in trespass. You violated my rights. The officer would argue that they were empowered by the Constitution, via the Supremacy Clause, to enforce federal law. The defendant would then respond that the Supremacy Clause doesn't empower federal officers to exceed the powers delegated to them by federal law to violate statutes or to violate constitutional rights. These suits were usually brought against federal officials because before the enactment of the 14th Amendment, about which more shortly, few constitutional prohibitions of consequence applied to state officers. This would change. When Marshall was writing, no statute or common law created a cause of action that enabled you to sue specifically for violation of constitutional rights. It's just that many constitutional rights were also common law rights, so a constitution violating action, say a taking of property without just compensation, could be litigated through the procedural framework of general common law torts. A federal statute that's now known as Section 1983, where it's codified, changed this framework by creating a direct cause of action against state officials for the deprivation of any rights secured by the Constitution.
Evan, I'm sorry to interrupt. To advance the slides,
Oh.
you need to use the computer that's up there.
How do I do that?
Hit the touchpad that should advance.
Okay, sorry about that. So in 1871, Congress enacts what is known as Section 1983 today. Section 1983 came from the Reconstruction Congress and from the need to follow up the battlefield defeat of the Confederacy with the defeat of white supremacist terrorism that arose in its wake. By the time the 14th Amendment was ratified in 1868, there was dire need for vigorous enforcement. At an April 1867 meeting in Nashville, Tennessee, the Ku Klux Klan began its transformation from a loose group of marauders into a tightly structured terrorist organization that promoted white supremacy through whippings, rapes, and murders, and effectively disabled law enforcement in several southern states. Governors cried out for federal assistance. President Ulysses S. Grant responded, calling upon Congress to act to enforce the 14th and the 15th Amendments, the latter of which was ratified in 1870. Congress responded with enforcement acts that targeted public and private conduct that threatened civil rights. One of those enforcement acts was known as the Ku Klux Klan Act of 1871. The KKK Act is the source of the language that you now find in Section 1983. And as originally enacted, the Ku Klux Klan Act provided that any person who under color of any law, statute, ordinance, regulation, custom, or usage of any state shall subject or cause to be subjected any person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution of the United States shall, any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding, be liable to the party injured. Shall be liable. Any law, statute, ordinance, regulation, custom, or state usage to the contrary notwithstanding. Doesn't seem to be anything in there about immunities, like the opposite, no immunities, explicitly. Now, to be sure, there's a canon of statutory interpretation that says that you read statutory text with a common law history in light of that history. So if there was a common law history of qualified immunity for government officials, those immunities might be implied. Trouble is, there's no such history. There's some reason to believe that there existed judicial immunity, that judges weren't liable to civil actions for official conduct, but not general qualified immunity. And to the extent that states did create immunity doctrines, the KKK Act seems to displace them. Shall be liable any law, statute, ordinance, regulation, custom, or state usage to the contrary notwithstanding. Now, the Reconstruction Congress, prophetically, churned out civil rights statutes like this, like the KKK Act, in part because it didn't trust the federal courts in general and the Supreme Court that had decided Dred Scott and Prigg v. Pennsylvania in particular to enforce the amended Constitution on its own. This was the Supreme Court that played no small role in contributing to the need for amendment because of what Republicans regarded as its misunderstanding of the antebellum Constitution. And this skepticism proved justified as the court narrowly interpreted both the rights secured by the 14th Amendment and Congress's power to enforce it. So not only did it hold that the 14th Amendment didn't protect very much, for example, it protected the right to access sub-treasuries but not the freedom of speech, but it held that Congress couldn't take a different view. It couldn't interpret the Constitution more expansively than the Supreme Court. The court's decision in what are inaptly known as the civil rights cases of 1883 really exemplify how the court both narrowed rights and limited power. The court held unconstitutional the Civil Rights Act of 1875, which prohibited discrimination in places of public accommodation. The court reasoned that the right not to be discriminated against by private as opposed to state actors wasn't protected by the 14th Amendment, and also Congress can't take the view that it is. This decision practically disabled Congress from attacking Jim Crow. And it still hasn't actually been overruled. When the Warren courts in the 1960s upheld the Civil Rights Act of 1964, it did so on Commerce Clause rather than 14th Amendment grounds. Now, the Warren court did take a much broader view of what rights the 14th Amendment protected than did the Reconstruction-era court. The Reconstruction-era court denied that the 14th Amendment incorporated the first 8 amendments, the freedom of speech, freedom from unreasonable searches and seizures against the states. The Warren court not only incorporated most of these rights, it elaborated them in very ambitious ways, particularly rights that secure the interests of people suspected of crimes and defendants in criminal cases, and particularly in ways that constrain police. And in Monroe v. Pape, the court held that municipalities could be sued under Section 1983 for rights violations by individual police officers. In Monroe itself, 13 Chicago police officers broke into the residence of the Monroe family and forced James Monroe and his wife to stand naked in the living room, while other officers ransacked every room of the house, emptying drawers and ripping mattress covers. The race of the members of the Monroe family isn't mentioned in the opinion, but they were black. So too was Robert Hall, who was beaten to death by Georgia police officers while in custody. The Supreme Court in Screws v. United States overturned the conviction of those officers under a criminal statute that contained language similar to 1983. But in Monroe, the court distinguished Screws because that statute imposed criminal penalties for acts willfully done, with the specific intent to deprive someone of a constitutional right. Section 1983 doesn't contain that language, so the court reasoned that the ordinary rules governing civil liability applied. Section 1983, the court said, should be read against the backdrop of tort liability that makes a man responsible for the natural consequences of his actions. But the court didn't really elaborate exactly what that meant. As Professor Schwartz will no doubt explain, when it did so, it didn't apply background rules that existed in 1871. It created new ones.
So we've just heard about the initial creation of the right to sue under the Ku Klux Klan Act, what became Section 1983, and the reinvigoration of Section 1983 through Monroe versus Pape. I'm now here to deliver some less uplifting news about the qualified immunity defense. So 6 years after Monroe versus Pape was decided, the Supreme Court created qualified immunity. And I agree with Evan, this is a creation. This is not part of the language of Section 1983. It appears nowhere in the Constitution. But in 1967, in a case called Pearson versus Ray, the Supreme Court held that there should be some form of immunity for officers who are acting in good faith. This case, Pearson versus Ray, the facts underlying the case happened just around the time that Monroe versus Pape actually was decided. It was a case where black and white ministers had traveled to the South as part of the civil rights movement. They went into a segregated coffee shop in a bus station. A police officer told them to leave. They wouldn't leave, arrested them. And the statute under which the officer arrested the ministers was later found to be unconstitutional. So the Supreme Court decided that the officer who did the arresting should be entitled to this qualified immunity because the officer was acting in good faith, because the officer believed that they were enforcing a law something that was good law. And when they talked about this good faith defense, they described it as something that they were sort of borrowing from Mississippi state law. So at the time the qualified immunity was created, it was understood to be a good faith defense. But the Supreme Court didn't stop there and has, over the past several decades, interpreted qualified immunity in a way that makes it more and more and more difficult to overcome. The first main shift was in 1982 in a case called Harlow versus Fitzgerald, where the Supreme Court did entirely away with the good faith standard that it had created and replaced it with a standard called clearly established law. So instead of granting officers qualified immunity when they were acting in good faith, the Supreme Court said, no, the proper test should be whether the officer was violating clearly established law, and they should be entitled to qualified immunity if the law was not clearly established. This move from a subjective good faith standard to an objective clearly established law standard was justified by the court by interests in shielding, I use that word a lot, shielding officers from the costs and burdens and distractions of being sued. And the idea was that if you have a subjective standard like good faith, you will need to depose the officer and possibly go to trial. If you have an objective standard, then the idea is that you could resolve the case quickly based simply on the law without going through discovery and trial. The Supreme Court did not explain what clearly established law meant, and over the subsequent decades, the court has given us some clues about what exactly clearly established law means. And the overwhelming sense that you get from the Supreme Court's decisions is that it is an exceedingly difficult standard to meet. The Supreme Court has repeatedly said that there needs to be a prior court case that clearly establishes the law, except in obvious situations, which we'll turn to in just one moment. The court hasn't been completely clear about which courts can clearly establish the law, and circuits are different about this, but it's fair to assume that the Supreme Court can clearly establish the law, and circuits, the circuit that is your circuit can clearly establish the law, or a consensus of cases from across the circuits can clearly establish the law. But to clearly establish the law, the Supreme Court has also said that the prior finding of unconstitutionality must be, quote, particularized to the facts of the case. This is something the court said in the 80s, and they've said repeatedly in the Roberts era. And what that has come to mean in the Supreme Court's view is it's not enough that an officer has violated a general legal principle. It's not enough, for example, that an officer has violated the general legal principle that an officer cannot use force against a person who has surrendered and is not resisting. Instead, you have to find a prior case in which an officer uses a similar type of force in a case in which a person is demonstrating that they are not resisting and that they are surrendering in a similar way. And there are, unfortunately, many examples of just how hair-splitting these cases can be, with one of my favorite, meaning least favorite, cases being Baxter versus Bracey, a Sixth Circuit case where a man burgled a home, was surrounded by police, sat down with his hands in the air, and officers nevertheless released a police dog on him who bit him under his arm because he had his hands in the air. He sued, and there was a prior case in that same circuit saying that it was unconstitutional, excessive force, to release a police dog on a person who had surrendered by lying down. But in the view of this Sixth Circuit, the factual distinctions between the person sitting with their hands in the air and the person surrendering by lying down were sufficient to find that the law was not clearly established. If that hair splitting isn't enough, the problem is compounded by the fact that the Supreme Court has said that lower courts, when deciding qualified immunity, don't have to rule on whether the law was unconstitutional or whether conduct was unconstitutional before granting qualified immunity. So the court has told plaintiffs they have to find a prior court case with nearly identical facts, and then have told lower courts they don't have to issue those decisions. Now, there is one bright spot in a case called Hope versus Pelzer in 2002, and then very recently in November of 2020, the Supreme Court has ruled that if there is an obvious constitutional violation, you don't need a prior court case on point. And in this most recent case, Taylor versus Riojas, decided in November of 2020, there was a sense of optimism among those of us who think a lot about qualified immunity that perhaps Taylor versus Riojas and this reinvigoration of the idea of obvious violations might be a sign that the Supreme Court was changing their view. But not so fast. In 2021, there were two Supreme Court decisions on qualified immunity that beat the old drum that we had been hearing before about the need for particularity in prior court decisions and the need to clearly establish the law with prior decisions. Both of these cases, Rivera Villegas and City of Talahiqua, are use of force cases in which the court's analysis suggests that you have to, once again, find a prior court case with nearly identical facts to overcome qualified immunity. Now, qualified immunity is received a lot of attention in recent years, and justifiably so, but it is only one of many barriers to relief in these cases. One is the challenges of proving municipal liability. There is proving that local governments themselves are liable. There is not respondeat superior liability for local governments. Instead, the Supreme Court in 1987 said that you have to show an unlawful policy or custom caused the violation. And that can be a policy unlawful on its face or the conduct of a final policymaker like the police chief. But far more often, these claims are claims of a failure to train or failure to supervise that are very difficult to prove. And although local governments don't have the protections of qualified immunity, my research suggests that it is as difficult or more difficult to prove municipal liability than it is to overcome qualified immunity for individual officers. And then there's limits on injunctive relief. And I will not go through all of this in the interest of time, but the short takeaway from the development of the Supreme Court's law in this area is that the court has created a lot of barriers to getting forward-looking relief in these cases, and requiring that there be proof of a, quote, great and immediate threat, that whatever conduct is the basis for the lawsuit will happen again in the future, which can be very difficult, particularly in police use of force cases. It's very difficult to prove that you yourself have been, not only have been subjected to unlawful force in the past, but will in that precise way again in the future. And if you're thinking about federal agents, there's a whole other set of challenges. Section 1983 does not apply to federal officers, but the Supreme Court recognized that a claim against a federal officer could be brought directly under the Constitution in 1971. But they have, in a similar way that they have expanded qualified immunity, they have shrunken the power to sue federal officials, such that at this point, unless there happens to be a prior court case holding unconstitutional or allowing the right to sue for a particular fact pattern, the Supreme Court doesn't believe that Congress has authorized additional rights to sue. And even if you get past those hurdles when you're suing a federal officer, then qualified immunity also applies. So you have to show that your claim fits in within one of the three kinds of prior claims that have been recognized by the Supreme Court as bases to sue for federal officers, and then you have to get through all of the barriers of qualified immunity.
Finally, the uplifting part. Just kidding, actually. Wait, I'm hitting the arrow. Oh, there we go. This is also about hurdles, and I'll try to keep it brief, because there are a lot of hurdles. But I do think it's important to, recognize that in addition to qualified immunity, in addition to other doctrines that Joanna was speaking about, there's a whole interlocking set of doctrines and other practical impediments that make it extremely difficult to successfully sue law enforcement. And it's not like, you have to deal with one per case. Oftentimes you have to deal with a whole bunch of intersecting ones that kind of complement each other and create barriers in a particular case. Certainly, simply getting access to counsel can be extremely difficult for a civil rights plaintiff who's suing law enforcement. If anyone tweets that two of the best civil rights lawyers who do that work happen to be in the room right now, a whole bunch of people might immediately show up because. Quick shout out to Flint and Steve, but a really serious point that there's an enormous demand and shortage of counsel relative to the need, and the sort of group of attorneys who either work at nonprofits or who have sort of the courage to go off on their own and stake their livelihood on the difficulty of suing police officers and overcoming the various barriers that plaintiffs in these cases encounter are pretty few and hard to come by, particularly in light of the scope of the need and the economic realities that unless, and Joanna lays this out very powerfully in her book, unless the harm is so severe, really, often that means death or catastrophic injury. The economic realities of successfully bringing a case in a way that enables one to make a livelihood because of the doctrines that restrict attorneys' fees can be prohibitive. In an article that's mentioned in the CLE materials, I pull that move where you say a thing that has been said many times before, but you give it a new name. And so I call this like practical immunity, this kind of, it's not qualified immunity, it's not a legal doctrine, but there are just interlocking sources of restrictions that make it very difficult to prevail against the police or other law enforcement officers. I'll touch very briefly on the one of the items, which is just, this is multiplied many times on behalf of people who are incarcerated because of additional restrictions that come from the PLRA, because of the difficulty of just gathering. I'm sorry, the Prison Litigation Reform Act, which restricts access to counsel as well as access to courts for prisoners. The difficulty of gathering evidence while incarcerated. The fact that for many of these cases, you need an expert witness in order to overcome summary judgment, which is out of reach for the vast majority of incarcerated litigants. And one that I really want to stress most heavily in my remaining time, it's the second bullet on the slide, is this idea of who or what is the reasonable juror for summary judgment purposes in a civil rights case. As many of you surely know, the standard for summary judgment is that no reasonable juror could find for the non-movement. Usually it's the law enforcement defendant, the officer who's moving for summary judgment in these cases. And it's been demonstrated empirically that there is a significant divergence between what those in power as judges think of as reasonable as a matter of law when it comes to the reasonable use of force, and what lay people who would have the opportunity to decide these cases, if the cases more routinely went to juries, think. This was demonstrated in particular in a law review article regarding the Scott versus Harris case in the Supreme Court. That was kind of early in the current era of video cases involving police misconduct, and it showed a police chase which ends with the officer bumping. I mean, bumping is a soft word. Ramming the car in front of him in the chase, knocking it off the road intentionally, causing catastrophic injury to the driver that the officer was pursuing. The Supreme Court says, "Oh, look at that video. It's clearly the officer was acting reasonable. No rational person could think otherwise." When you show that video, and it has been showed subsequently to lay people, not only do a lot of people find it obviously unreasonable what the police are doing, but there is a vast disparity according to demographic categories, including race, as to who thinks the police conduct is reasonable versus unreasonable. And the point, as I see it, is that these aren't, oftentimes these aren't cases where you need to be a technical expert or where going to law school makes you any better at being able to sort out what is reasonable versus what is unreasonable. People's perspectives differ, and those perspectives are informed by their life experience, and that's the very purpose of having a jury, is to create a bulwark against the power of the state. And when a person has been profoundly, severely injured in the street by an agent of the state, this is precisely the sort of case where one needs a jury in order to play the role of lay society acting as a check on state power. And not simply a judge taking the case away, because a judge, after all, is just another variety, a particular variety of government official. And so the combination of the reasonableness standard, which allows the court to decide as a matter of law what is reasonable or what is not reasonable, or what it would be completely irrational for any juror to find as unreasonable, with the added gloss of qualified immunity layered on top of it, creates, what I consider to be one of the most, severe and significant hurdles against accountability for police through the civil trial system, which is, if ever there's a time when you want citizens to be able to pass judgment through the jury function on what the government has done to people, it's when the government has left someone dead in the street or severely injured in the street as a result of state-sanctioned force. Lawyers love to argue back and forth about how John Adams represented the British troops regarding the Boston Massacre, one of the most sort of well-known instances of government officials, armed government officials, acting against the populace in what became the United States. Some people will say, I can't believe John Adams representing those murderous redcoats. Others will say, way to go, John Adams, really the epitome of the defense bar and being willing to step up for everyone. I have never heard anyone say, what a waste of time. I can't believe the judge spent time on that case deciding, whether these British officers should have murdered these people. And so the idea of qualified immunity as something that is necessary to prevent a waste of officers' time or judicial resources, I don't think makes a whole lot of sense, because these are the very type of cases where it is most important to engage the populace and most critical to engage the court in taking the case seriously and allowing it to be decided where it should be decided. Oh, gee, I think I've sort of shaded into critiques. Oops. But and I've gone over time, so I'll leave it at that. Thank you.
You just hit the next slide.
I would, yes. Sorry, I got a little bit carried away there. All right.
And now, why don't the four of us, before we let Juan to us what the ABA's view are on this subject, let's just talk a little bit among ourselves about the myths behind qualified immunity and why they are myths. So let's start with the first one. One of the principal reasons that the courts gives for creating this qualified immunity in 1967 is that we don't want police officers to be faced with the financial consequences of being held liable if they make a mistake in enforcing the law. Is that a legitimate concern? Who wants to answer?
No, it's not a legitimate concern. Police officers are indemnified. There's no risk that any police officer is going to be mulcted, as I think Chief Justice Warren put it in Pearson, to a point where it hurts them personally. It's not to say that the money is insubstantial and that the costs on the part of the municipality of paying officers constitutional torts couldn't have some attenuated effect on training or discipline, but it's highly speculative. As
Right.
Joanna
Joanna, you want to discuss your research on
Yeah,
this?
I mean, at the time that the Supreme Court talked about concerns about officers being mulcted in damages, state legislatures across the country were creating indemnification statutes to do the exact same thing that the Supreme Court was hoping qualified immunity would do, meaning shield officers from financial responsibility in cases when they have, exceeded their authority. And my research showed that in 81 departments over a 6-year period, 99.98% of the dollars came from insurers or local government budgets. 0.02% came from officers in 2 departments out of the 81, with an average payment being $4,000, which is not the making of a bankruptcy petition. I do think that there are cases in which officers are denied indemnification. There are, for sure, and I've heard many examples of them. They're difficult to capture, those cases. But there's another reason why officers aren't bankrupted in those cases, which is that plaintiffs and their attorneys have limited financial incentive or other incentive to go through the effort of trying to collect on those cases. So if an officer is not going to be indemnified, the typical response is either to find an officer who will be indemnified or to bring a claim against the local government with the hopes that a settlement, will be negotiated with the municipality. Rarely is it to stick it to the officer and then, spend the resources to try to collect, unless they happen to have resources from another job or from, equity in a house or something. But it is not, in my research, anything that is commonly done.
Thank you. Let's talk about the second myth. So the other answer that we get from police officers is frequently, I need qualified immunity because otherwise I'll be held, and if I'm found liable for acting unconstitutionally, I can be disciplined for that or fired. So what is the real world show on that score? Evan, you want to start us off, and then why don't we just go down the panel and talk about it?
I'd just like to, reframe that question a little bit to understand what the officers in that question are actually suggesting. They are suggesting that fear of being disciplined or fired for violating the Constitution is a reason to preserve qualified immunity. They are asking for more freedom to be able to violate the Constitution without meaningful consequences. And even before getting into the question of whether materially they are actually liable to be disciplined or fired for violating the Constitution, I would just reject the whole premise as something that is a compelling argument in the first place.
Right.
In addition, I would say that I've researched the extent to which lawsuits play a role in police departments' decision making about their officers, and what I've found is that in most jurisdictions, the two things, the civil litigation and the internal discipline and investigation, are siloed one from the other, and what happens in litigation does not have an impact on what happens in the internal affairs investigation. And in fact, I've seen examples where an internal affairs investigation is halted or suspended while a civil rights suit is litigated. So there certainly can be high-profile cases, politically salient cases that can lead to an officer being disciplined or fired, but it's not the litigation itself that causes that.
And David or Juan, do you want to weigh in on how effectively our internal systems for disciplining police officers work here, at least locally and maybe nationally?
Well, quite poorly, I would say. Yeah, right. Yeah, I mean, and I'm sure Steve and Flint have like some particularly good examples of this, but the number of officers who have elicited false confessions through tortures and through torture and had repeated convictions thrown out and been perfectly fine from an employment and discipline, to say nothing of criminal prosecution's standpoint, is staggering, and in many cases, like, it's the same officers again and again, costing multiple people decades of their lives in prison, and then on top of that, costing the city again and again in multi-million-dollar judgments, not really suffering anything in terms of internal.
And in fact, I think,
Let me just offer this as a different thought that we haven't really touched on yet. The culture of these police departments and these agencies, where they kind of, protect each other. They've been friends for 5, 10, 15 years. And I actually have talked to some of these officers, and I will tell you, they have a very, I'm going to call it a tunnel vision mentality.
can we call it a warrior?
Warrior, okay, that's even probably a better phrase.
One of our panelists, I think, has written about that a little bit.
Yes, and the idea is they're going to go home tonight to be with their families. You may not, but I am. That's the officer talking.
Right.
And so they become very warlike or protective of their life and who they are, their lives and who they are. And so this internal culture where they protect each other, and I've even had one officer say to me, as a lawyer, Juan, you don't risk your life every day. You go to court, or you're sitting at your desk, you're writing a brief, or you're on a Zoom, in mediation, or doing a deposition, your life's not in danger. Every single day, their life's in danger. And that's their mentality.
No, that's exactly right.
Yeah.
And actually, I think the downside of that is reflected in their training that over the years has trained them as though they are soldiers in a war,
Right.
in an urban war, and that their training is you shoot first to protect yourself if there's any question or ambiguity.
Right. Ask
And
questions
that has
later.
resulted
Right.
in many, many unnecessary instances of officers firing, killing people, maiming people, when it didn't have to go in that direction if you didn't have officers on such a hair trigger basis.
Right.
And that's a major factor in the way that we need to change the training of officers.
Absolutely.
I mean, according to the OSHA statistics on occupational fatalities, is not being a police officer is not among the top 10 in
Right.
terms of occupational fatalities. It's I think closer to the top. It's it's like
Coal miner.
outdoor jobs, like being a lumberjack or doing cable
Coal
line
miner,
repair.
right.
That probably that too, but not policing.
Right. And of course, the response to that is, of course, but if we didn't act like warriors, it would be an even more dangerous job. And then you just get into this circle where you can't actually shake the mentality because it has been so consistently perpetuated, including by the Supreme Court, which has, in a case called Graham v. Connor, stressed that, that is central to the training of every officer, that split-second decisions by officers in life and death situations are to be given heavy deference by the courts. And Graham has subsequently been elaborated in ways that suggest that pretty much any decision that makes any decision by a police officer that makes its way into litigation is one that should be looked at through the lens of life or death is at stake here.
Right, and in some recent cases, we can even see that here. Basically, anytime the police see a gun, they shoot somebody. They're not trained to fire the second shot. They're trained to fire the first shot. And in many cases, that results in shots being fired where there's good reason to believe that shots would not have been fired at all if the officer had not fired first.
And just think about how that interacts with Bruin, which recognized the right to carry firearms in public. So now we've got a situation where officers are claiming that in order to protect themselves and in order to get home safely, they need to affirmatively violate people's constitutional rights to bear arms simply as a function of, so you have Supreme Court decisions that on the one hand say defer to officers when they use violence, and on the other hand say that people have the right to carry concealed weapons.
Right.
Right. Well, right. So it's not violating their Second Amendment rights. They have their right to carry, but then the officers have their
Then the
right
officers are
to
trained to shoot them if they see a gun.
And one thing to say also, the point about Graham and all of the deference that it gives to officers in making split-second decisions includes language that there can be mistakes made in the split second, and those do not amount to constitutional violations if the force used was objectively reasonable. And to return to the point, the topic of myths, often the defenses of qualified immunity talk not just about bankrupting officers, but the whole phrase is bankrupting officers who make mistakes in a split second. Right. And indemnification, negates the first half of that claim. The Graham versus Connor negates the second half, which is to say that the way in which the court has interpreted the Fourth Amendment, you don't need qualified immunity to protect against mistakes made in a split second because the Constitution already does.
Right. All right, let's talk about the final myth here of that if you're reading the appellate court cases, you would think that the police officers out there are constantly asking themselves as they're chasing someone, which case is this more like this case or that case? And how realistic do we think that is?
It's not realistic at all. I mean, I think it defies logic to anyone who has ever read court cases. And if you can imagine reading hundreds of them or thousands of them, which, there are hundreds or thousands of cases that would apply, that would clearly establish the law for qualified immunity purposes. Litigators who sit in Zooms all day can't remember all those cases. An officer who is interacting on the street and making split-second decisions clearly isn't either. And I have done. I mean, even though this is an obvious point, I also, just to put a dot on the I or a cross on the T, I looked at hundreds of California trainings and policy manuals, and there's no mention. I mean, there's mention of Graham repeatedly, and then scenarios that officers are given to become comfortable with what Graham provides, but they're not trained at all about these decisions. And although the Supreme Court repeatedly talks about qualified immunity as a need for notice, even people who represent officers, no one believes that officers actually read these cases or remember
Or would actually
them.
think it's okay to release this police dog because the guy is sitting there rather than lying down.
Right, and the whole point about fair notice, this is language that comes from the criminal law in the context of the rule of lenity, whereby you interpret a criminal statute in case of ambiguity to not apply in a doubtful case. You do that because the burden of being convicted as a criminal, of being labeled as a felon, carries stigmatization, not to mention caging, that the prospect of civil liability that you're actually not paying because it's indemnified does not. So the appeal to fair notice really elides a very big difference between the stakes that are at play in the context of the criminal law, where fair notice really is a very important concern, and here.
Right, exactly. So I think I could fairly summarize that. We seem to be largely in agreement that there aren't really incentives for police officers to change their conduct in the real world based on qualified immunity or many other of the other hurdles that exist. So where does that leave us as a legal profession? Juan, you want to take it from there? You need to hit the next slide too, I think.
There we go. All right. And so, for these reasons, in August of 2020, the American Bar Association called for all federal, state, local, tribal, and territorial legislatures to eliminate or at minimum to substantially curtail the legal defense of qualified immunity. Qualified immunity, clearly by what we've heard this afternoon, has proven to be a profound obstacle to one of the most fundamental objectives of our justice system, remedying the deprivation of our constitutional rights. The ABA has long advocated for the vigorous enforcement of constitutional rights and calls for all legislatures to take this action. I urge you, when you have time, to first read Joanna's book, but then read the ABA's resolution 301A from August of 2020. I stand here on behalf of the ABA as chair of the ABA Civil Rights and Social Justice section that proposed this resolution in response to the George Floyd killing in the summer of 2020. I also want to put this discussion in some historical context. And Evan, right? I'm sorry. Evan kind of touched on this in his remarks about the historical context of policing in this country. Sadly, advances in many of our civil rights movements have come in response to tragedy facing particularly African Americans. The Civil Rights Act was passed in response to 4 little girls being bombed in Birmingham in 1963. The Public Housing Act was passed in 1968 in response to the assassination of Dr. King. Confederate flags were taken down all across the country a few years ago in response to 9 African Americans being killed in a church in Charleston, South Carolina. And so the elevation of the conversation around qualified immunity has come in a real sense because of what we all witnessed for those horrific minutes in May of 2020, where we're all locked in our homes, unable to go anywhere. And so these conversations, while there's a historical discussion and work to push these issues and advance these causes, they seem to get more attention after these type of tragedies. And so here we are today, 3 years later, and we're still wrestling with this issue. Congress, and it's in the resolution, the House rather, not the Senate, passed a bill called the George Floyd Act in 2020 that called for the elimination of qualified immunity, or at least the significant curtailing of it. That bill got no action in the Senate, and the person who was president at the time obviously would not have signed that bill. That has not happened. That bill is still pending in Congress. It's been reintroduced in this session, but because of the nature of Congress right now, likely not to go anywhere in the House, still will be very difficult in the Senate, given how close and how partisan the Senate is. The ABA's resolution, and I urge you to read it, ultimately leaves you with this reality, and I think our speakers have touched on this by their presentations. This comes down to a political question. Do legislatures, do local governments, does our federal government have the political will to eliminate qualified immunity? It's a very difficult proposition if that's going to happen. Because if you are, quote, against qualified immunity, the politics becomes this. You're against what? You're not being tough on crime, right?
Law and order.
Law and order, exactly. And that becomes very difficult. And it becomes an issue that it gets very hard to get elected if you're not for law and order. And even in communities of color, there's this myth that they don't want police. That is a lie. That is a myth. Everyone wants to live in a safe neighborhood. Everyone wants to go to good schools and have safe schools. But they want policing that they can trust, where there's a relationship of trust and there's a partnership in those communities with the police departments. And so this becomes a very challenging situation when you're talking to local officials in the city council, when you're talking to mayors, when you're talking to governors, because they have political realities in their states and their cities that make these things challenging. And the other point I want to make before I conclude is that oftentimes these issues are negotiated in collective bargaining agreements between the city officials and the police unions. And no one wants to run for mayor if the police union's not with you, right? And so, again, that's a challenge that we've got to think through strategically and creatively, because the court process, the court systems have already kind of laid out the significant challenges. How do we deal with these issues in a political context ultimately becomes, in my view, the only way to really solve these challenges moving forward. And the ABA resolution, again, calls on federal, state, local, and tribal territories to eliminate or substantially limit or minimize or curtail the defense of qualified immunity. Thank you.
So we have gone a little over on the first part of the program, and that leaves us about 10 minutes maybe to talk about some proposed reforms. So I will quickly shepherd a quick discussion of some of these with our panel members. So first, let's talk just about some proposed legal doctrinal reforms that the Supreme Court could do tomorrow or Congress could enact. One of them would simply be to eliminate qualified immunity, as we've talked about, and I think we've covered that one pretty well. A second would be simply to eliminate the clearly established law requirement and go back to a good faith subjective defense. Another one would be to eliminate the enhanced pleading requirements that require people to plead cases before they have an opportunity to find the facts. And finally, we could eliminate the Monell immunity doctrine and adopt the normal respondent superior doctrine that applies in the rest of the world. And finally, we could, where police departments are acting unconstitutionally, as they did in the Rizzo case and in the LA case, we could allow the courts to impose injunctive relief and prevent and order those police departments to stop those practices. Right now, in part because of some of the legislation Congress enacted, the only way to do that is to first have some big incident that then justifies Department of Justice coming in, doing an investigation, finding that there's a pattern of unconstitutional policing, and then filing a lawsuit and eventually resulting in a consent decree where you can enforce those kinds of reforms on police departments. But we shouldn't have to go through that whole rigmarole in order to get injunctive relief. A second set of somewhat broader proposed reforms is let's improve our internal discipline system so that police officers who are acting unconstitutionally, particularly if there's a consistent pattern, are effectively disciplined or fired. We have locally, I would just note that we have gone through 3 variations of the police oversight panel that investigates charges of excessive force by the use of Chicago police, from the Office of Professional Standards to IPRA and now to COPA. And we also now have a Deputy Inspector General for the City of Chicago who looks at pattern and practice claims. Those things are all good, but they still need to work, and we are still in a world where it's still an open question as to whether they will work or not, notwithstanding all the reforms to date. Another reform is to actually require officers to contribute some money to cases where they're charged with civil rights violations. And actually, Colorado did adopt a statute like this in 2020, and Joanna's book talks about that. I think it limits the officer's participation to 5% or $25,000 in any case, which is significant but not likely to cause a bankruptcy, but certainly should be enough to get an officer's attention. Another way to bring pressure here is to do it through local governments. And here we do see tension between the budgetary aspects of local governments, where we saw Lori Lightfoot's call for a risk management proposal in Chicago that would stop us from spending $500 million over a decade on police settlements. We've seen it in New York, where the comptroller has long urged that the police department budget should be dinged, based in part on the size of the judgments that have to be paid because of police misconduct. Improving training and supervision is a point that Juan was talking about, and that really is the key to changing the culture and improving policing to minimize these constitutional violations. Consent decrees, as I've mentioned, are another way to do it, but it's often difficult to get consensus among the police ranks to go along with the changes that the lawyers propose in the consent decrees. Unbundling the police refers to the fact that we do have the police serving many functions for which they are not trained and they do not do a good job of. So handling calls involving individuals suffering mental health incidents, suffering drug overdoses, some domestic dispute things. Those things in many cases could be better handled by other people, and we do have projects, including one here in Chicago, where we send out other professionals, like mental health professionals, with the police to try and handle those in a better way, and eventually to try and relieve the police of some of the responsibility for going out on all those types of calls. And finally, we can learn from lawsuits, and this is a matter of discipline in any city government, that they should be looking back over why they had to settle all these lawsuits and pay all this money and trying to figure out a way to improve things, which again goes to basically fundamentally changing the way we police people. Going beyond reforms, there is the abolitionist challenge. And here I want to defer to Evan. And Evan, why don't you talk to us for a few minutes about these things.
Sure. So let me just say at the outset that if qualified immunity is eliminated tomorrow, I'm happy. That's an unqualified good, no pun intended, but now acknowledged. And I thought in preparing my remarks about just stopping there, Joanna's book is great. She's right. Do what she says. Do what the ABA says. All that being said, if qualified immunity is eliminated tomorrow, stop and frisk is still constitutional. Pretextual traffic stops are still constitutional. Police can still arrest you and put you in jail overnight for a fine-only, non-arrestable offense because the Supreme Court has said that that is constitutional. And that, I think, invites us to think more deeply about not only qualified immunity, but the numerous areas of constitutional law and doctrine governing access to the courts that have enabled the killings of so many people of color that have led to the given momentum to the kinds of reforms that we are talking about here. In the very same year that Pearson v. Ray was decided, a Fourth Amendment case was decided that has been as important to how the Constitution has been interpreted to apply to police as pretty much any, and that's Terry v. Ohio. So the same Supreme Court that was reforming policing as it understood it through decisions like MAP, creating the exclusionary rule for Fourth Amendment violations like Miranda, requiring that people be warned of their rights in the context of custodial interrogations, was also at the same time making up stuff about the common law, both in Terry, where it says that, reasonable suspicion was at common law a justification for stopping somebody, which it wasn't, and in Pearson saying that at common law there existed this thing called qualified immunity. So I think it's important in thinking about pursuing the effort to reform qualified immunity or hopefully eliminating it, about the conditions that gave rise to a place where the court was prepared to do that. Because if you look at the Warren Court's decisions and a lot of subsequent decisions retrenching on certain of its commitments, what you see is kind of an uncritical acceptance of the basic legitimacy and reasonable operation of the police as such. And what I think we have reason to believe in recent years, given where those decisions have led us, is that that uncritical view can too easily be used to justify the exercise of discretion by police that has a differential racial impact, a differential class impact, and perpetuates inequality that, as Paul Butler, who wrote a provocative article criticizing Gideon v. Wainwright, of all things from the left, pointed out, actually has imprisoned more people of color proportionally than were imprisoned at the time of Gideon. I do ultimately think that qualified immunity, or the abolition of qualified immunity, would be extremely valuable. It's an effort through which people who otherwise don't have access to electoral politics can hold the government to account and command resources. Civil litigation is. It's an opportunity to kind of open up the black box of policing policy. There are ways in which the courts can serve democracy, but ultimately I am concerned that if we only focus on qualified immunity without thinking more broadly and structurally, we'll get rid of qualified immunity only to leave in place the conditions that make decisions like Pearson v. Ray and Terry v. Ohio and Illinois v. Wardlow, and we could go on and on, possible.
Let me just ask the other panel members as well, sort of some concluding thoughts from them before we start taking questions and answers. Joanna, you want to start us off?
Well, I certainly agree that qualified immunity is, although a very important topic, one piece of the puzzle, and all of the other practical immunities and other substantive challenges of getting past these cases are exceedingly difficult. And make success in these cases far more difficult than they should be. I guess my one concluding remark would be that there are cases that continue to be brought and and should continue to be brought. And I hope that the dark news about all of these challenges hopefully would not overly discourage people from practicing in this area, because it is so critically important for these cases to be brought. And there are important successes that we haven't touched on here, but they have made very meaningful changes in individuals' lives and in the shape of our civil rights. So that'll be my concluding high note.
I will
thought.
refrain from saying anything about the current Supreme Court and what it was doing. David?
I think my earlier comments sort of go to this in a way, but it does kind of baffle me that when the state has killed someone, not just that there's qualified immunity, but that there's this whole usual panoply of ways to prevent a trial from happening, like summary judgment, motion to dismiss, all of this stuff that is about the inefficiency and risk of trial and the consumption of resources. I don't understand why there's anything to talk about there when the government has officially given someone the means to kill another person, and that person has used it to do just that. It seems like in a case like that, of course, at minimum, it's worth the court's time. It's worth utilizing the jury system to get to an answer.
Thank you. Juan?
I want to kind of piggyback on what Evan said about the other aspects of our criminal justice system and policing system. For me, this discussion really is a broader discussion about our values as a society, as a country, as a democracy. And 3 years ago, in light of the George Floyd incident, there was this broad discussion around defunding the police, right? Remember that term? Which had, terrible political consequences. And just it's a terrible phrase if you dare run for office under that banner, right? But what it did do was open up the discussion around what should policing look like in our society. And I think it's important that we really think about these broader issues, because we don't want to just narrow it to qualified immunity, but how do we police? How do we have safe neighborhoods? How do we have safe communities? Because right now, we live in a world where, and this is kind of what I want to leave you with, there are people being killed by police who either are doing petty, minimal crimes or no crime at all. But we also live in a society where you can kill 9 people in a church and they can arrest you, and because you say you're hungry, they take you to, I think, the local Burger King for a sandwich. That is fundamentally wrong. We've got to really, talk about those fundamental truths when we think about, our democracy, safe communities, policing. And so I just want to leave you with that reality that we have a lot of work to do in this space. And I'm glad that, you touched on some of the other aspects of policing.
Thank you. And we'll have a few minutes for questions and answers, and then I'll give you a few concluding instructions. So, are there questions and answers from from people here at the audience? We'll start there. Jerry.
I'd like to pick up on a point that Professor Bernick started in comments you have about the tension between Bruin, who says you have a right to carry a firearm outside for your personal protection. And under qualified immunity, if the officer sees that weapon and says, well, I felt threatened, so I shot you, it would seem that those are really in conflict. Are there any cases that you're aware of that are pending that would address that tension? And that would, as an African American, not that I don't own a gun and I'm not into guns, but I think it would be insane for me to walk around in an open carry state with a firearm.
And
I'd get shot.
Jerry, and funny, in the black community, we have a solution. You want to get rid of carry conceal? Every black man in America should go buy a gun legally. The law will change. They'll change that real fast. I mean, go ahead.
So I was just going to observe that the timing of Terry v. Ohio with respect to the Black Panthers advocating
right.
open carry in California,
Right.
1967, 1968, 1967, 1968, may not have been entirely coincidental. So here's how I expect the Supreme Court would resolve that question if it ever does take it up, keeping in mind that Terry v. Ohio was decided far before the court recognized an individual right to bear arms. The fact that you have an individual right to bear arms doesn't mean that it is not dangerous in a way that an officer could respond to with deadly force under Graham in a split second, without suggesting that, so this is the point that Joanna made, it would be framed as, well, the police aren't violating your constitutional rights. You have an ability to exercise your constitutional rights, but constitutional rights, well, you have a constitutional right to carry a hunting knife, right? So there's a case called Michigan v. Long in which the Supreme Court says, well, the fact that Long had a visible hunting knife that was legal under Michigan law at the time that he was pulled over for a traffic stop, and he was stopped and frisked on the basis of it, doesn't affect anything. It may be lawful, it's still a weapon. So the Supreme Court is gonna have to make a choice here. Do they rebalance the equilibrium between law enforcement needs as they perceive them and individual rights in light of the fact that they're recognizing new constitutional rights, or do they rely upon language in these decisions that basically say you may have a constitutional right to do things, but police officers, if they reasonably feel threatened by them, can respond consistently with the Fourth Amendment by doing so. It's a bad scene, and there are cases that have really focused on not precisely what you're talking about, but reasonable suspicion in the context of states where it is legal to carry weapons, and post-Bruin that's going to be more and more pressing. Can you reasonably suspect somebody of criminal activity if they're carrying a gun, if the Supreme Court says you have a constitutional right to carry a gun? It's going to be a little bit more difficult.
Yeah, I would say I think that I don't, unfortunately, I don't think the Supreme Court's going to see a conflict in this at all. I think they're going to look case by case, and what they're going to assess is, did the officer reasonably fear for his safety or the safety of others? And I think you're 100% right that the racial implications of this and how officers perceive threat, how officers perceive threat and the circumstances in which they perceive threat will have implicit bias wrapped all the way around it. So if a black man shows up to Walmart with a semi-automatic weapon and a white man shows up to another Walmart with a semi-automatic weapon, I think that the results could be very different, and the use of force against of the black man in Walmart might well be. I don't want an experiment about this. I don't want ever to see these cases, but I fear that the way in which the amount of discretion that officers have to assess whether force is relevant just necessarily can take into account unspoken issues of race and racism. So.
And implicit bias, of course, has no constitutional status as the court has interpreted the Constitution. If we absent discriminatory intent to treat somebody differently because of their race, it is not unconstitutional for officers to act on the basis of implicit biases.
And of course, it's illegal to teach it in many states now.
Yeah.
That's why this training is so important, because these racial dynamics are already culturally embedded in our society. Jerry, what you touched on, I think is true for many African American men. I don't own a gun either. I don't know if my good friend Cannon Lambert does, but I will tell you, here's my question. Why aren't white men afraid to carry a gun?
There is,
That-
I suspect
that's-
maybe
go
we've
ahead.
seen this on YouTube. There are
Yeah.
like sequence of videos.
Yeah.
A youngish white man walks down the street with an assault rifle.
Yeah, I've
and he
seen that.
engages in a lengthy discussion
Yeah.
with the police officer.
Yeah.
And he lets him go. And a black man walks down the same street a few days later, and they're like 3 police cars, 5 officers, yells, get down on the pavement right now,
Yeah.
the gun's drawn,
Right.
they arrest him, and they take the gun away from him. And I would not do that experiment.
Right.
Before we finish, let me just quickly cover a couple questions that we received online. So one from someone who I think some of you know said, how should advocates who oppose qualified immunity navigate the tension between presenting the parade of horribles around qualified immunity and arguing that, in fact, the myths behind qualified immunity are overstated? Anybody?
So one thing that this is something that comes up with my research a fair bit, because my research has shown that a relatively small percentage of cases are actually dismissed on qualified immunity grounds, fewer than 4% of police misconduct cases filed. And so people look at that and say, well, then qualified immunity is not so bad. And the 2 responses that I give, one is that part of the reason that qualified immunity dismisses relatively few cases is that there are so many other barriers to relief. The challenges of finding a lawyer, pleading a complaint, proving a constitutional violation. It's only once you get past all of those that qualified immunity comes into play. And so, and this is the second point, qualified immunity, which was intended to result in the dismissal of quote unquote insubstantial cases, ends up doing its work on the most substantial cases, the cases that couldn't get dismissed any other way, which is why it's important to get rid of the doctrine so that those critically important cases can have their day before a jury, so that lawyers don't have to spend all of the time and energy and expense litigating qualified immunity. But also, it does not mean, because of all these other barriers, that courthouses are going to overflow with frivolous lawsuits, because there are these other barriers. So I think it's a complicated point, but I think that it's at least all consistent in my mind.
All right, a second question on.
Stop citing me for that.
Yeah, well, I think it might have been
A second online question that I wanted to cover just before we conclude is someone wants to know, what do we think about the Illinois Attorney General Kwame Raoul's proposed reform of a state licensure system for police? Juan, you want to start us off and just go down the panel?
No, so I think, that has some merit to it. One, universal system. Us lawyers, we live under that type of, rule. It's one, code of ethics for all of us. So I think that has some merit to it versus, city by city or county by county. And hopefully he'll get some support out of that in the legislature.
David?
No comment for me.
Yeah, I think generally thinking about more regulation of law enforcement and more centralization of standards and trainings and licensing and accreditation all make sense. And it could have been in one of our slides about other proposed reforms as well. It's definitely worth considering.
Evan?
I'll just say that there are lots of lawyers who have not yet been disbarred that I would not trust with my legal affairs. So I would not necessarily look at the presence of a license as I have kind of concerns about legitimation there. But yes, all else being equal, more regulation is good.
Okay. Any other questions from the audience before we close out the program? Okay then. Before we close and sign off, I have a few sort of announcements. First, I want to thank each of our panelists for their wonderful presentations and comments today. You all did a wonderful job in my view. And second, I wanted to thank Alexis Carr, who I think may have had to leave, for all her help in putting this program together under her trying circumstances. And third, I want to thank Jerry Brown again for the use of this facility and for his courtesies. Next, I want to make you all aware of 2 upcoming related events. First, tonight from 5:30 to 7, the Chicago Lawyers Committee for Civil Rights Under the Law, headed by David, will be sponsoring a book signing event for Joanna Schwartz's Shielded book at the offices of Kirkland and Ellis tonight. It's not too late to register for that event at the Chicago Lawyers website. Second, sometime in the second half of June, the Chicago Council of Lawyers Civil Liberties Committee will be holding its annual panel discussion on police oversight in Chicago, moderated by former head of COPA, Sharon Fairley feel free to contact me for any details on that. As I mentioned at the outset, if you're seeking CLE credit and have not provided us with your ARDC number, please respond to an email that you should be receiving tomorrow following the completion of this program. And finally, we hope to post a recording of this program on a newly created YouTube channel for the ACS Chicago Lawyers Chapter. Check the chapter's website for details. And thank you all again for attending.